Hello everyone. Legal Insights welcomes you all to yet another episode. In our previous lecture, we discussed about succession and inheritance. Today, as a continuation of our previous lecture, we shall give a brief idea about some of the terminologies which are associated with this topic. So, without further ado, let's begin. In our previous lecture, we introduced the term will. So, we shall now understand as to what does a will mean and what are the essential requirements of a valid will. First of all, we should understand that a will is nothing but a written document which shows the desire of a deceased person regarding the distribution of his estate. Thus, if a will is found to be valid and enforceable, the estate of the deceased would be distributed in accordance with the same. It is in this regard we should keep in our mind that Indian Succession Act of 1925, which governs the domain of wills, has not prescribed any particular format in this regard. However, the essential requirements could be summarized as follows. Firstly, it should be written and drafted in a manner that the intention of the testator, that is, the maker of the will, becomes unambiguous and clear. We must also keep in mind that since the fundamental object is to give effect to the desire of the testator, small or trivial errors in the name or details of the property can be ignored, and the entire document should be read as a whole to understand the true intention that the testator wanted to convey. Along with this, the will should be signed by the testator and by two other witnesses. But a question that naturally crops up as to what will happen to those who cannot sign due to his or her being an illiterate person, or if the person is suffering from any illness. In such a case, such person can put his thumb impression. A very important point in this regard to be kept in mind is that these witnesses should be independent persons and not beneficiaries under the will. So, in addition to all this, we should also keep in our mind that wills are not required to be registered and they need not be made on a stamped paper. So friends, the next question that comes to our mind is that can a person make multiple wills in his lifetime? Well, the answer to this is a vehement yes. Yes, a person can do so. But in such a case, only the last written will shall prevail. But unlike in case of cell deeds, in case we find that there is a case of inconsistency between two parts of the same will, the later part will prevail over the earlier part, as the testator is allowed to change his mind. Now, we shall try to explain the concept of probate. Probate is basically proving of a will or establishing the validity of the will. A probate can be granted by the district judge or by the concerned high court, where the high court has original jurisdiction. And we shall also keep in our mind that the original will is required to be filed along with the petition for probate. Now, according to Section 2F of the Indian Succession Act of 1925, probate refers to a copy of the will that is certified by the seal of a court of competent jurisdiction. Through probate, rights pertaining to administration of an estate is granted to the applicant, who is an executor under the will too. Thus, it is a judicial process through which the validity and authenticity of a will is determined in a court of law. In this process, the executor of the will, beneficiaries, and the value of the estate are determined. Thus, my dear friends, probate helps the executor to receive a certification from the court that he is duly authorized to administer the estate of the testator under the will. A corollary question that naturally comes to our mind is can probate be granted to anyone and everyone? Well, as per the Act of 1925, probate cannot be granted to any person who is a minor or is of unsound mind. Friends, I hope by this time you have got a clear idea about probate and about will. That's all, friends. Thank you for watching this video. I hope by this time you have got a brief idea about the different terminologies which are associated with the concept of inheritance and succession. Stay tuned to keep yourself updated. Thank you.